issues of fraud and must be investigated. And ladies and gentlemen of the media, we've also taken notice of desperate attempts by the Attorney General Godfred Odame and some individuals to impugn the propriety of the GPGC EPA, which was executed under the NDC Mahama administration. These people have suggested that the GPGC EPA was unnecessary and its terms defective. But friends from the media, nothing could be further from the truth than this claim. In the first place, how can the MPP, who fully participated in the approval of the GPGC agreement in Parliament, both at the Mines and Energy Committee level and at the plenary, turn around to question the propriety of same? It is important to make the point that aside the fact that the GPGC EPA was approved by Cabinet and Parliament, its terms are materially the same as all the other PPAs executed by the then Power Ministry, some of which, like Car Power and Sem Power, have been extended by the Akufo-Addo administration. In fact, as I've already explained, the terms of the GPGC EPA were to a large extent more favorable to the interests of the Republic of Ghana than all the other PPAs executed at the time. What even makes this claim ridiculous and preposterous is that the Akufo-Addo government itself has by its own conduct expressed faith and confidence in the GPGC agreement. The government terminated the GPGC EPA and actually proceeded to make a counterclaim against GPGC for early termination damages at the arbitration by relying on provisions in the same agreement. And this is very revealing. Any lawyer will understand the seriousness of this point, because a counterclaim is a fresh action. If you are sued in court and certain claims are made against you, and you make a counterclaim against the plaintiff as a defendant or a respondent, your counterclaim is like a fresh suit against the person who sued you. In other words, you are telling the court that the one who sued me is not entitled to these damages. Rather, I am the one entitled to these damages. And so order him to rather pay these damages to me. And a counterclaim is considered as a fresh action in law. So the question is, if, according to Godfred Odame, the GPGC agreement the Mahama administration signed is defective, then why will you terminate that agreement by relying on provisions in that same agreement and then make a counterclaim against GPGC by relying on provisions in the same agreement? Clearly, the Attorney General and Minister for Justice cannot approbate and reprobate. It's like saying that you are a Muslim, but you eat pork, or you like pork meat. It doesn't work like that. If you think the agreement is defective, then you cannot be making a counterclaim on the basis of a defective agreement. So the question we are asking Godfred Odame is this: why has the Akufo-Addo government turned around to question the integrity and propriety of the very agreement they relied on for their counterclaim? If the Akufo-Addo government thought that agreement was defective, why did they rely on provisions in same for the termination and counterclaim? And why did they not raise the issue of the impropriety of the agreement either in the termination letter of 13 February 2018 or at the arbitration proceedings? For emphasis, the GPGC EPA was approved by Parliament and its terms were very favorable to the interests of Ghana. The claim by the Attorney General Godfred Odame that the GPGC PPA was unnecessary and defective, and a subsequent threat to refer same to the CID for investigations is nothing but a post facto face saving gimmick, which must be treated with outright contempt. As I have already indicated, the facts show that the $170 million judgment debt awarded to GPGC was occasioned by the criminal negligence, complete dereliction of duty, and recklessness of the Akufo-Addo government in terminating the EPA without any lawful justification, and not the signing of the agreement. Therefore, those who have to be held responsible are those who were involved in the termination of the agreement on the basis of fictitious and contrived claims, when they knew the danger their actions could portend for this country, and not those who signed the agreement, which was approved by Parliament in any case. Distinguished friends from the media, another point worthy of mention in this discussion is the crass incompetence and sloppiness with which the Attorney General's Department and the Akufo-Addo government handled the court processes to set aside the arbitral award. As you may be aware, at arbitration, the Republic of Ghana was represented by lawyers from the AG's department, which included the Deputy AG at the time and now Attorney General Godfred Odame, and a Ghanaian law firm, Ambufa & Partners. We've seen the Attorney General trying to play Pontius Pilate and create the impression that he was not involved in this whole matter, and that his attention was drawn to this case only after his appointment as Attorney General. Well, ladies and gentlemen, that is not true, because it is clear from the arbitral award that he was one of the lawyers on record. In fact, our checks show that at most of the sittings of the arbitration tribunal, he, Godfred Odame, was the one who led the government of Ghana side. So we want to show you, maybe somebody will think that what we are saying is not factual. So let's show you an extract from the arbitral award, which has his name there as one of the lawyers who represented the Republic of Ghana. So, Counsel for Respondents, Ms. Gloria Ifua Akufu, Mr. Godfred Odame, Mrs. Helen Akpene Awuziwu, Mrs. Anna Pell Ikiwumi Srebo,